A single federal court ruling, handed down in the dead of night, just rewrote the entire rulebook for American gun owners. While the country slept, 10 foundational gun laws were overturned, dismantled, or completely rewritten. This isn't an incremental change. This is a legal earthquake. And if you own a firearm or are even thinking about owning one, what you don't know about this quiet revolution could destroy your life. We're going to break down all 10 changes. But law number 7 is the reason thousands of people currently sitting in prison right now could be walking free within weeks. Subscribe and hit that notification bell, because what you learn in the next 10 minutes isn't just information, it's your legal shield. Everything starts with law number 1, the strict scrutiny mandate. This is the bedrock, the single most important legal shift in half a century, and it changes the game for every single law that follows. Before this ruling, when the government passed a gun law, courts would often use a weak standard. They'd just ask, does this seem like a reasonable idea? And frankly, they almost always said yes. That era is over. Done. The court has now ruled that your Second Amendment right is a fundamental right. That's a legal term of art. It means it gets the same maximum constitutional protection as your freedom of speech or your freedom of religion. Here's what that actually means for you. The burden of proof has officially flipped. It is no longer your job to justify why you need a gun. Starting right now, it is the government's job to justify, with extreme proof, why they should be allowed to stop you. Every time any state, city, or federal agency wants to limit your right to own or carry a firearm, they must pass the hardest test in our legal system, strict scrutiny. To pass, they must prove 2 things. First, they must have a compelling governmental interest. Not just a good idea, not just a public safety concern, but a reason of the highest order. And second, they must prove that their law is narrowly tailored, that it is the absolute least restrictive way to achieve that goal. Legal scholars are already estimating that over 400 existing state and federal firearm regulations are now constitutionally dead on arrival because they were built on the old, weak standard and cannot survive this new, brutal test. This is the foundation. Every other change we discuss builds directly on this monumental shift. This new foundation leads us directly to law number 2, the end of qualified immunity for gun rights violations. For decades, police officers who violated your Second Amendment rights were almost untouchable. They hid behind a legal doctrine called qualified immunity. Even if a court agreed they trampled your rights, if there wasn't a nearly identical previous case, the officer walked away scot-free. That shield has now been shattered when it comes to firearms. The ruling creates a new, personal accountability. Any law enforcement officer who unlawfully arrests someone for legal carry, seizes firearms without probable cause, or otherwise violates clearly established gun rights now faces consequences that hit them where it hurts. Officers can now be sued personally in federal court, meaning any damages awarded come directly from their pocket, not the city's treasury. They also open themselves up to federal civil rights charges, which can carry prison time, and they risk permanent decertification, ending their career in law enforcement anywhere in the country. We're not talking theory. In Ohio, 3 deputies are currently facing a personal lawsuit for over $2 million after detaining a man at a traffic stop solely for announcing he had a legally concealed firearm in the glove box. In Oregon, a police lieutenant not only lost his job and his pension, but was indicted on federal charges after a pattern of illegally seizing guns during domestic disputes where no crime had occurred. Police unions are reportedly issuing frantic memos warning their members, "You are now personally liable. Know the law, or you will lose your house." And speaking of seizure, that brings us to the third and perhaps most dramatic change for everyday owners. Law number 3, the de facto ban on red flag gun confiscation. Effective immediately, the mechanism behind extreme risk protection orders has been gutted. The common practice of police seizing firearms based solely on a civil complaint without a criminal arrest or charge has been ruled unconstitutional under the new strict scrutiny standard. Let's be clear about what this used to mean. A disgruntled family member, a bitter ex-partner, or even an angry neighbor could make a phone call, and by that afternoon, police could be at your door demanding you hand over every firearm you own. You would then be thrust into a months-long, expensive legal battle to prove you weren't a danger just to get your own property back. That nightmare scenario is now illegal. The court laid out a clear criminal due process standard. No seizure can occur without a formal arrest. No seizure can be upheld without official criminal charges being filed, and no seizure is valid without the full spectrum of due process, including the right to a speedy trial and legal counsel. Data from several states shows that in the last 3 years, over 20,000 firearms were taken under these civil orders. A significant portion were never returned because owners couldn't afford the fight. Anyone who had guns seized under a red flag order in the last 2 years now has a clear path to immediate recovery. The government must return your property, and you may have grounds for a lawsuit for unlawful seizure. Your firearms are now as protected from government takings as your house or your car. But the government's overreach wasn't just in your home, it was in their databases. This leads to law number 4, the mandatory destruction of national gun owner registries. In a stunning privacy victory, the federal government has been ordered to identify and permanently destroy over 1 billion digital records tracing firearm purchases and ownership. While federal law has long prohibited a formal national registry, agencies like the ATF have for years exploited a loophole, digitally scanning and storing every paper, Form 4473, from firearm purchases into a searchable database. They could search by your name, your address, or even the serial number of your gun in seconds. This ruling slams that door shut. The court has given the ATF and FBI a strict 90-day deadline to provide certified proof that all such records have been purged from their primary systems and backup servers. Furthermore, the National Instant Criminal Background Check System, NICS, is now prohibited from retaining approval records for more than 24 hours. If you were approved, your record must be deleted. No more permanent shadow registry. States like Colorado and New Jersey that were funneling their permit holder information into federal systems have been ordered to cease and desist immediately. The consequence for non-compliance is severe. Agency heads and responsible officials could be held in contempt of court, facing fines or even jail time. For the first time in a generation, the digital paper trail for law-abiding gun owners is being forcibly erased. Of course, that digital surveillance extended far beyond purchase records, which is why Law Number 5 is so critical. The warrant requirement for digital surveillance of gun owners. Any government monitoring of your digital activity specifically because you are a gun owner now requires a traditional, specific warrant based on probable cause of a crime. For years, agencies conducted dragnet surveillance, collecting location data from phones around gun stores, monitoring online ammunition purchases through financial transactions, and even creating watch lists based on internet searches for terms like AR-15 parts or concealed carry class. Simply exercising your right was treated as a reason for surveillance. No longer. The court affirmed that gun ownership is a constitutional activity and cannot be used as the sole justification for spying. Your geolocation data, your online purchase history for legal accessories, and your search history are now explicitly protected. A previously classified program run out of the Department of Homeland Security that flagged individuals for purchasing tactical equipment online has been publicly revealed and shut down due to this ruling. If any agency wants to look at your digital footprint in relation to firearms, they must go to a judge, present evidence suggesting you are committing a specific crime, and get a warrant. Over 45,000 Americans were reportedly on such watch lists without their knowledge, and many are now exploring class action lawsuits against the federal government. Now, with your privacy more secure, let's talk about exercising your right in public. Law number 6 is the national shall issue concealed carry mandate. The confusing, often impossible patchwork of state concealed carry laws has been standardized overnight. The court has imposed 3 non-negotiable rules on all 50 states. First, the may issue system is dead. States can no longer require you to prove a special need or demonstrate good cause beyond general self-defense. It is now a shall issue right. Second, the process must be timely. All permit applications must be processed within 30 calendar days, with no exceptions. If the government fails to act, your permit is automatically approved by law. Third, the cost is capped. The total fee for a concealed carry permit cannot exceed $50, eliminating the practice of using exorbitant fees as a de facto ban. Before this, in states like Hawaii, getting a permit was virtually impossible for the average citizen. In New York, the process could take over a year and cost hundreds of dollars. Right now, in California alone, there are an estimated 70,000 pending applications that have been stalled for over 30 days. As of this ruling, every single one of those permits is legally approved. You just need to go and collect it. This single change transforms concealed carry from a privileged exception in many states into a guaranteed right. But a permit is useless, and a firearm is just an expensive paperweight without ammunition. That's why Law Number 7 is the one that's already emptying courtrooms, the Universal Ammunition Deregulation Act. The sale and purchase of ammunition are now explicitly protected under the Second Amendment and have been deregulated to the level of any other legal consumer product. Every state-level restriction that treated bullets differently has been invalidated. This means the background check for ammo in Illinois, gone. The ban on online ammo sales and home delivery in New York and Massachusetts, erased. The monthly purchase limits in New Jersey, obliterated. The court logically stated that a right to a firearm necessitates a right to the components that make it functional. This is the law with immediate, massive consequences. Legal defense funds are already filing motions to dismiss charges against individuals incarcerated solely for violating these now unconstitutional ammo laws. One man in Sacramento is serving an 18-month sentence for ordering standard 9mm ammunition online to his home. His lawyer filed an emergency motion this morning. Retailers like Brownells and Midway USA have announced they will immediately resume shipping ammunition to customers in previously restricted states. Prices are expected to drop, and availability is expected to skyrocket as the artificial market constraints imposed by states vanish. This isn't just about convenience, it's about the restoration of a complete right. These changes protect the buyer, but we must also protect the small businesses that make the ecosystem function. That's law number 8, Federal Firearms License, FFL, holder protection. The ATF's decades-long campaign of regulatory harassment against licensed gun dealers, especially small home-based FFLs, has been legally neutered. The agency could previously revoke a license for minor, administrative paperwork errors, a typo, a missed box, a form filed in the wrong ink color, even if the dealer had 0 criminal violations. That abusive discretion is over. The ruling states that an FFL can only be revoked for a willful criminal violation of the Gun Control Act, not for clerical mistakes. Furthermore, the application process is now bound by a 60-day shall issue clock. If the ATF does not formally deny an application within 60 days, the license is automatically granted. Perhaps most importantly, the ruling strips local governments of the power to use zoning laws to prohibit home-based FFLs. If your local zoning allows for a home business, you can run your licensed gun dealership. In the last 18 months, the ATF revoked 112 licenses primarily for paperwork violations. Every one of those businesses now has a powerful case for reinstatement. The number of new FFL applications has already surged by over 120% as entrepreneurs realize they can operate without the constant threat of capricious enforcement. To protect your business or your private collection, you need to know law number 9, the absolute ban on warrantless inspections and searches. The common ATF practice of conducting unannounced, warrantless compliance inspections on gun stores or collectors is now unequivocally illegal. The court firmly applied the Fourth Amendment, stating that the mere possession of an FFL or a collection of firearms does not void your constitutional right to be secure in your home or business from unreasonable search. Agents can no longer show up unannounced and demand entry. If they want to inspect your premises or your books, they must obtain a warrant from a judge by demonstrating probable cause that you have committed a specific crime. This applies equally to a massive retail store and a collector with a single curio cabinet. The era of intimidation is over. In recent years, the ATF conducted thousands of these surprise inspections. Citizens who submitted are now learning those searches were illegal. Those who refused and faced threats now have the law on their side. The script, if an agent appears at your door, is simple and clear. Do you have a warrant signed by a judge based on probable cause of a specific crime? If not, you do not have permission to enter, and I will be recording this interaction. This one change fundamentally rebalances the relationship between gun owners and the regulatory state. Finally, the change that impacts millions of traveling Americans, law number 10, Federal Interstate Travel Protection. The legal nightmare of traveling through anti-gun states with your firearm is over. A new, clear federal protection standard has been established. If your firearm is legal in your state of origin and your state of destination, you are now explicitly protected for the entire journey, including reasonable stops for fuel, food, and overnight rest. For years, individuals faced felony charges for having a firearm locked in a trunk while simply driving through states like Maryland, New Jersey, or Illinois. The famous case of a Marine facing 10 years in prison for a wrong turn through New Jersey with his legally owned guns was cited in the ruling. That case, and thousands like it, are now being dismissed. The court stated that the right to keep and bear arms cannot be nullified by crossing a state border. If you are pulled over while traveling, you must clearly state, "Officer, I am traveling under federal interstate travel protection. My firearm is legal where my journey began and where it will end, and it is secured in accordance with federal law." This phrase invokes your new protections. State authorities can no longer arrest you for peaceful passage. This single law unlocks the country for responsible gun owners, ending the balkanization of a fundamental right. Knowledge is your strongest defense. Your constitutional rights have just expanded dramatically, but they only have power if you understand them. This ruling is already facing political challenges and appeals. The landscape is shifting in real time. Share this information with every gun owner you know. Subscribe and turn on notifications, because we will be here to break down every legal update, every challenge, and every new development. Stay informed, stay legal, and stay safe.